The broadcast is now starting. All attendees are in listen-only mode.
Good afternoon, everyone, and thank you for joining today's webinar. We are going to get started in about a minute. I just wanted to make sure to say hello to everyone and thank you again for taking time out of your busy schedules. We know December is a crazy month, so thank you for taking time to join us today for our harassment prevention training webinar. And so again, going to give you guys about another minute to get settled. We have a lot of people joining us, so go ahead and sit back, relax, make sure that your monitor is being fully utilized for the presentation, and we'll be starting soon. All right, let's go ahead and get today's webinar started. Again, thank you all so much for taking time to join us today. I see a lot of more people jumping on. Our attendee counts and going to continue to increase, so thank you so much for taking time to join us. We're thrilled to have you on. We have all sorts of different organizations on the line with us today. We have current clients, we have people that just received the invite to join the webinar, and so they wanted to jump on because the topic interested them. So thank you for taking time to join us. Today's webinar is going to be brought to you by our partners over at HR AnswerLink. They're going to be going through harassment prevention training. So we're excited about that topic. But before we get going, make sure that your full monitor is being utilized by our screen share. Hopefully you become familiar with GoToWebinar and you're comfortable with it. Keep in mind that during the webinar you can ask questions, but we're going to do a Q&A session at the end. So don't think we're ignoring you throughout the webinar. Just go ahead and ask your questions and we will get to them at the end. Again, this is Kristen Justice with BeyondPay, and I am coming to you outside of Philadelphia, and our partners at HR AnswerLink are going to be doing this webinar today over harassment prevention training. So before we get going, I do want to do a quick overview of who BeyondPay is, in case you're not sure of who we are. You received this invite, it interested you, so you're joining, but you're wondering who BeyondPay is. So just to give you a quick overview, we are a full HRIS and payroll provider. So we not only provide a partnership with HR AnswerLink and offering you a plethora of resources in regards to HR topics, but we also help you with bringing on new people within your company with recruitment, applicant tracking, the onboarding process for enrollment, managing your HR department, time tracking, payroll, and tax filing. We also have ACA compliance. So we're a full functioning HRIS and payroll provider. And what we do is we have these webinars because we want to make sure that you all stay fully informed on hot topics and things that we're told are of pertinent topics to you. So at this point, I want to go ahead and hand it over to HR AnswerLink. We are so excited to have Rebecca on the line to be conducting this webinar with us today. So without further ado, I'm going to turn it over to Sarah, and she is going to go ahead and get today's harassment prevention training webinar underway.
Wonderful. Thank you so much for that, Kristen. We are really excited to be here. Before we begin, I would love to introduce you to our presenter, Rebecca. Rebecca is an HR representative with a diverse background in human resources and training management from the temporary staffing and insurance industries. She received her bachelor's degree from La Roche College in Pittsburgh, PA. Rebecca has a knack for translating complex regulatory language into real-world scenarios, allowing users to quickly utilize the content in their daily activities. So I know Kristen mentioned this already, but we would love this to be an interactive training and do invite you to chat in any questions you've got throughout the presentation. We look forward to responding during the question and answer session scheduled afterwards. At this time, I'll turn it over to you, Rebecca. Thanks again, everyone, for joining us.
Thanks, everyone. And Kristen, if you could just show my screen. Actually, you know what? I think I'm able to do that now. So sorry about that, false alarm. You all should be able to see my screen in just a second.
And we are seeing it.
Okay, perfect. Okay, so hopefully everybody should be able to see my agenda. I apologize that it took me a minute to get that set up, but if for some reason you can't, go ahead and send me a chat and let me know, and we'll work to get that fixed on our end. Perfect. So today we're going to be talking about harassment prevention training, and oftentimes this causes people to have some trepidation. It's certainly a sensitive topic, but I'm going to be giving you some best practices today as a specialist in employee relations that will really help you make sure that you're preventing harassment from happening in the first place, and if it does occur in your workplace, that you are able to take steps to immediately mitigate that. The law does require you to do something as soon as you find out that something untoward could be happening in the workplace, and we'll talk a lot more about that as we move forward. So, as a part of this training, we're going to be covering a variety of issues related to workplace diversity and inclusion as well. And it's not just going to be about compliance with state and federal laws, because I know that would probably be pretty boring just to sit and listen to someone talk about compliance. And then we'll start with the underlying regulations. We'll go through some definitions, some best practices, and a few scenarios. Okay, so our learning objectives today are, we just want to know, what are the definitions of unlawful harassment? What are your responsibilities to investigate, report any complaints or concerns? And again, how do you prevent harassment and discrimination from occurring in the workplace? Now, the law doesn't prohibit simple teasing or offhand comments. Oftentimes I'll have a client call me and maybe they have a manager who typically a really good person. They don't have a lot of complaints from their employees, but they said one silly thing or made a bad decision in a moment, and it wasn't rising to the level of severe and pervasive. Now, severe and pervasive is something that we're going to be discussing quite a bit as we move forward. So the law does not say that a simple one-time event that is not malicious in intent, it needs to immediately result in a termination decision. So I just kind of wanted to set that stage a bit before we talk about what exactly severe and pervasive is as far as the law is concerned. And on the screen here, you'll see some of our recent sexual harassment charges. This is data compiled by our friends over at the EEOC, and they are responsible for investigating any claims of harassment in the workplace. So as you can see, there has been quite a spike around the 2000, 2001 point, and we've come down until we got around 2008 and 2009. And my personal interpretation of this is we are also experiencing some economic turmoil during these times, some recession. And so oftentimes when employees are in a desperate situation or organizations are just trying to figure out how they're going to survive, oftentimes employees will perceive things perhaps that more severe than they are, and they'll file a charge against their employer. So oftentimes, if employees are feeling an intense pressure, they might feel that the workplace has treated them poorly or created a hostile work environment somehow. And that's important because we want to make sure that we understand the definitions of a hostile work environment. So if an employee says something to the effect of, I feel that I'm being harassed, or I feel that this working environment is not conducive to my success, these are the kinds of things that even, not direct statements, we do need to kind of dig deeper into that a bit and figure out if anything is actually occurring before it gets to the point where the employee feels it's not being heard and they're going to the EEOC. Okay, so as managers and supervisors, really respect in the workplace is one of the best tools to make sure that you're not inadvertently contributing to an environment, or if you are in an environment that you're not contributing to but you're just seeing something happen, that you can take immediate steps to stop it. And typically when employees feel that they are respected and valued, they don't see any perceptions of any sort of behavior being committed against them that is offensive. If everybody's treating each other with respect, we're really going to narrow down any instances of harassment allegations in the workplace. So I can't stress enough, positive employee relations are really the foundation for making sure that organizations aren't facing claims of harassment, because everything really just comes out of that positive place, and employees feel valued and like they are welcome contributors. And that's really our first line of defense, making sure the harassment doesn't occur. So just some common courtesy pieces here. Oftentimes I hear a client who will say, I just feel like in meetings this particular employee is singled out by their manager, or I feel like they're just treated a little bit differently. That could quickly lead to a claim of a hostile working environment. And typically in these situations, I recommend that employers, again, from a positive employee relations perspective, it's just so important that employees feel valued and appreciated. So as much as we can do to impart positive employee relations in our workplace, again, this really is going to help prevent any claims of disrespectful treatment. And then another thing that I want to have on all of your radars is pioneers in the anti-bullying arena are our friends over in California. California has actually made it unlawful to perpetrate abusive conduct in the workplace. And California is often a pioneer in all kinds of employment law that later becomes normal for the rest of the 50 states. So just be aware that there is legislation pending in many states that would make bullying, or the legal definition is abusive conduct, also illegal in the workplace. So if you have any questions about the differences, we'll definitely talk about it just a bit. But also here in the HR Support Center, we can help you with an anti-bullying policy as well as an anti-harassment policy. Okay, so just wrapping up our section here on respectful communications. Respect differences and diversity. It's important to note that everyone has different learning and communication styles, and ultimately, when we're treating others with respect, you and your team are ultimately going to be more successful and the business will be rewarded. Oftentimes we have, organizations, especially we kind of see these on the news, where like there's this locker room culture and, people are just disrespectful towards each other. They have inappropriate nicknames and so on and so forth. These are the kinds of organizations that do not thrive. And they typically end up being the kinds of organizations that make national news when their employees' grievance is heard by up to the Supreme Court, for example. That's where we get a lot of the case law that we have. Inappropriate things were happening in the workplace, and the employee was so aggrieved that they took their complaints to federal court. So we certainly don't want to have that sort of environment in our organization. Okay, let's talk about federal and state laws. Now, there are big three, I like to call them. Those are our friends in California, Connecticut, and Maine. Now, these states actually mandate harassment prevention for managers. Now, if you're joining us from any of these states, this is a really good foundation, the training that you have now, but those states require this to be a 2-hour training. So if you have questions on how to attend the training that actually would fall under the regulations of either of those states, please feel free to send us a chat or give us a call later, and we'll certainly help you with that. But for now, I just wanted to make you aware of those big three, as I call them, and we're going to be spending a lot of time really just thinking about the federal definitions as we move forward. So the federal regulations, there are a couple different laws in place that are important to know. And I first want to introduce again our friends at the Equal Employment Opportunity Commission, or the EEOC, as I'll refer to them for now. They are responsible for investigating any claims of harassment in the workplace. So the federal definition of harassment, it is mandated by Title VII. Now, Title VII is the crux of the 1964 Civil Rights Act, and this law makes employers responsible for preventing and stopping sexual harassment that occurs on the job. Now, Title VII is going to apply to private and most public employers with 15, so that's 15, or more employees. There is a statute of limitations that is 180 calendar days from the date the discrimination took place, or 300 calendar days if a state or local agency enforces a law that prohibits discrimination in the workplace. Now, other definitions and amendments to Title VII and the civil rights acts are the Pregnancy Discrimination Act, the ADA, and GINA. And GINA would be the law that makes it not okay to discriminate against someone based on their genetic information. So those are quite complex, and they have their own guidelines and best practices associated with them. So if you have questions about the ADA, GINA, or the Pregnancy Discrimination Act, please let us know. We'll be happy to help. But I just wanted to get those on your radar and make sure that you're aware of that if anything ever were to occur in your workplace that you'd like to talk about a little bit more. Okay. So on this screen, let's discuss some protected categories. And what I really want to emphasize here is that every human being is a part of a protected class. There isn't one of us on the phone today who wouldn't enjoy some protection under some class that we belong to. So for example, it's illegal to discriminate against someone because of their race or color, because of their sexual orientation, military status, their gender, marital status, age, and you kind of get the idea. So one important thing to point out is illegal harassment may be harassment based on any of these protected classes. So we often only think of sexual harassment, which is definitely what gets the most attention, but many don't think of harassment based on religion, military service, and so on. And it's really important to remember that illegal harassment can be based on any protected category, and it could even be instigated by anyone, regardless of their class status. So for example, there have been some cases where you know, men will make disparaging comments about other men, you know, or people of a certain ethnic group will discriminate against other people in the same ethnic group based on specific perceived characteristics. So even if you're in the same class, you can still harass others who are in that class with you by making disparaging comments about them. So these are just some important caveats to keep in mind and to make sure that we have these in our knowledge base, so if we see somebody making comments like that, for example, that we can go ahead and stop it. Okay. Let's get further into the definitions of unlawful harassment. So in addressing unlawful harassment, we're really just going to discuss what does this mean. So generally, any unwelcome verbal or physical conduct based on any protected category constitutes harassment when, now this is the key, the conduct is sufficiently severe or pervasive to create a hostile working environment. This is what courts really focus on. Does it happen frequently? And is it so severe that a reasonable person would be offended by what's happening? And that reasonable person definition is what we really want to keep in the back of our mind. So if we know about something that's happening in our workplace and we're not really sure whether or not we need to take any action, and we're not quite sure if it would rise, in our opinions, to the level of illegal harassment, pull out that reasonable person definition. And I think that most of you would probably consider yourselves reasonable people. So if you think that you and your similarly situated peers would be offended by whatever is happening, typically that is an indication that you should definitely be investigating and stopping that behavior. Okay, perfect. And I'm just checking a couple chats that came in to make sure that no one's having technical difficulty, and it sounds like you're not, so fantastic. I will be happy to get to those questions at the end. Okay, so let's do some case scenarios. I think that this really helps to set the stage of, you know, how to take the information that we're going to be talking about today and put it into a real-life scenario. So let's talk about Kathy and Jose. Kathy supervises Jose, and a mutual friend at work has a party on Saturday night attended by several people from work. It's absolutely not an employer-sponsored event. And after a couple drinks, Kathy tells Jose that she's attracted to him, and she tries to kiss him too. Now, Jose tries to politely decline and discourage her, but Kathy persists, asking Jose if he'll join her for dinner on Sunday night. Jose, again, politely declines. So what do you guys think? And I'm not going to ask you to chat these in because I know that we have you know, very little time to cover a lot of material, but I want you to think about these case scenarios as we talk through them, and I'll give you my advice. So in this situation, has Kathy sexually harassed Jose, and what should Jose do? Well, you know, Jose communicated to Kathy that he's not interested in her romantically. So if Kathy's behavior ceases after the dinner date invitation, this would be viewed as being uncomfortable and unwanted behavior, but not necessarily severe and pervasive harassment. However, if Kathy's behavior were to continue and it becomes severe and pervasive, then the behavior could be categorized as harassment. Now, this is not a work-related function, but individuals who work together, and specifically a supervisor and a subordinate. So there are some gray areas. At this point, it probably wouldn't be treated as workplace harassment or quid pro quo. However, it could absolutely easily get to that type of situation if Kathy doesn't stop it after Saturday night. So for example, if Kathy goes in on Monday and Tuesday and then Friday making the same kinds of advances, at that point, yes, that would be considered severe and pervasive sexual harassment. Jose has indicated that he does not want these advances, and she continues to advance toward him. So at that point, it would likely meet the definition of severe and pervasive. All right, so let's talk about quid pro quo harassment. Quid pro quo is Latin for this for that. So this is subjecting to submitting to or rejecting sexual advances or requests as a condition of employment. So if it's sufficient enough to show a threat of economic loss, then the employee would definitely have a case. So demands or requests that the complainant go out on dates with someone or engage in sexual conduct with the harasser would constitute a quid pro quo situation. So for example, if a supervisor tells the employee that if he or she were to date them or engage in a sexual encounter, then they'll receive a better bonus or promotion or something to that effect. That's what we're talking about when we look at this for that. All right, so let's look into that hostile work environment and reasonable person definition again. Now, the courts are going to consider a hostile working environment, unwelcome comments or conduct based on, first, it needs to be legally protected characteristic, and it needs to unreasonably interfere with an employee's work performance. And then it needs to create an intimidating, hostile, or offensive work environment for the individual being subjected to this. So again, if a reasonable person would view the situation as uncomfortable and would make them unable to do their work, we're likely looking at a hostile work environment situation if the behavior is based on any protected classes. And I really like to point this out because oftentimes I'll have a client ask me, am I experiencing a hostile work environment? I have a supervisor, for example, who just yells at people all the time. Well, it depends on what kinds of things that are being yelled, to be honest. Oftentimes there is not a legally protected definition of hostile work environment if you report to someone who's just frankly mean. They have to be making comments or singling people out based on a protected category. So that's definitely something to keep in mind when we're evaluating whether or not this is the definition of a hostile work environment. All right, so let's talk about some elements that are necessary for a claim. So the individual must be subject to unwelcome verbal or physical conduct because of the status of a member of a protected class. The harassment needs to be based on that membership and the conduct affected the employment or was intended to. Now, when we say affected the employment, we mean that a term or condition of employment had the purpose or effect of unreasonably interfering with work performance and creates an intimidating, hostile, or offensive work environment. Okay, so let's talk about, again, what is not harassment? Now, I definitely touched on, sometimes people are just rude and discourteous in the workplace. And if they are just being generally rude and discourteous, that's not always illegal. There are going to be people who are not nice in the workplace. And as long as their treatment of others that is less than ideal is not based on a protected category, then that doesn't meet the legal definition of harassment. So I know that that sometimes is really surprising to employers, and I want to be sure that I'm putting it out there. Also, simple teasing or offhand comments. I had a client call me recently who was distraught because a manager made a really silly comment to a subordinate, immediately repented, brought the allegations, the situation to the attention of their supervisor before any allegations could be made against them, and was really contrite for what they had done. And the employee supervisor was under the impression that since this comment had happened, that it must result in immediate termination. And that's definitely not the case. Again, we want to go back to that severe and pervasive piece when we're discussing whether or not this is someone that needs to not work for our organization anymore. We certainly can document a coaching and counseling, which I absolutely recommended, and make sure that that was retained in the employee's file in case anything like this were to ever happen again. Our decision might be a little bit different, but again, if employees make silly decisions and they didn't intend them and it's not severe and pervasive, that doesn't always mean that our only recourse is termination. Now, let's say that something happened one time and it was sufficiently severe that even the one time happening would definitely be grounds for termination. So for example, if the manager has been a star employee and let's say that Kathy calls Jose into her office and she asks Jose to submit to sexual contact with her in exchange for a bonus, well, that, of course, is very severe, isn't it? And even though she's been a star employee and it's never happened before, that's the kind of thing that we need to say, okay, a reasonable person would think that just this happening once, this person should probably be exited from the organization. So I kind of just want to set that tone so you can see the difference between offhand things that happen once or twice that are severe versus those that are not. Okay. So again, let's discuss the hostile work environment piece. So the raw definition is it's unwelcome behavior, it's offensive to the reasonable individual, it's severe and pervasive. I promise I won't say that too much more. I know you guys get it. And it alters the working conditions into an abusive environment. So questions to ask if you are tasked with investigating any of these concerns, or perhaps if you're seeing something that maybe is making you a little uncomfortable in the workplace. Ask yourself, is it frequent? Is it severe? Is it physically threatening or humiliating? Is it just something that is offensive that has been, uttered once? And does it interfere with anyone's work performance? Now, not just the person that it's directed toward. It could interfere with the work performance of anyone who happens to be within earshot. So that's something to keep in mind too. If you have two individuals who might be saying offensive things back and forth to one another, and both of them feel, oh, neither one of us is offended by this, somebody could be listening to that and be extraordinarily offended. And then that person could claim that they are being subject to a hostile work environment, and guess what? They would be. So definitely think about that third party too when we're considering a hostile work environment. All right, so let's talk about Carol and Hero. Whenever Carol sees Hero in the hallway, she says, hey, when are we going away to Vegas? And at first it didn't bother him, but after she said it again in earshot of some other employees, he complained. He's afraid that his girlfriend will hear rumors that he and Carol are planning a trip to Las Vegas. Now, as a manager, when you ask Carol about it, she says, oh, come on, I was just joking. Surely a little joke like that isn't illegal. Well, what do you guys think? Is Carol's conduct acceptable? And is Carol's conduct illegal? My general conclusion on this one is that, again, it could certainly rise to a level of illegal conduct if it continues. Hero's advised that he is uncomfortable with this. As soon as this has been made known to Carol, he needs to stop. Or I'm sorry, she needs to stop. Okay, so there's different categories of harassment that can occur in the workplace, and we're going to talk about some of those. And the first one that I want to discuss is verbal. So these are, dirty or off-color jokes, whistling, catcalls, sexual innuendos, flirting or sending, racy emails to someone, harassing voicemails, intimate nicknames that aren't wanted, making boasts or even talking about your sexual preferences or sex life. These are all definitions of verbal harassment that a reasonable person would find uncomfortable. Okay, so let's take a look at Luis. He's the CFO, and he's frequently asking Camilla, a payroll clerk, about her boyfriend, such as what she and her boyfriend did over the weekend, whether they're thinking of getting married or living together, and whether or not she's also dating other men. Now, Camilla complains about Luis's intrusive questions, And Luis angrily responds that he's just trying to boost morale by taking an interest in his employees' personal lives. Now, with this one, I am a little more uncomfortable than with the others. Repeated intrusive questions of a sexual nature would almost certainly be considered unlawful harassment. And also, Luis is the CFO, and this is his employee that he's talking to about her sex life, her boyfriend, and so on. And when she says something about it, he reacts angrily. Now, a reasonable person would consider his behavior, first of all, unwanted, and his reaction is retaliatory. How would you feel if you were Camilla? You've got the CFO shouting at you after you've told him that you're uncomfortable. So this certainly would be something that, as an HR manager, I would step in and mitigate ASAP. Now, there are verbal categories of harassment that fall into the other categories. So these are, of course, slurs and insults, ethnic jokes, name-calling, derogatory references, criticizing political beliefs. This is definitely something that's going to be rife, I believe, in the HR Support Center since we're in an election year. People get real fired up about politics, and they say things that could be really disparaging to other people, and maybe they probably just don't realize it. But again, these are the kinds of things that if they're happening in your workplace, try to get some professional guidance and see if we can put a stop to this before it becomes a harassment situation. Okay, a couple more case scenarios. I hope you guys enjoy these because I really like talking with you about them. And of course, we have sanitized names, but these are actual situations that we've seen in the HR Support Center. So we didn't make these up. These actually happened. Okay, so during a discussion among office employees about getting drunk over the weekend, Deborah tells them you should reject Satan's false pleasures and accept the Lord Jesus as your Savior. She then begins sending around religious-themed emails to all of the office employees, and she informs them that she'll be praying for them so that they will reject Satan's temptations. Is Deborah's conduct illegal? Well, harassment can be based on religion if it is repeated behavior. There may be people who subscribe to other religions or have other religious beliefs that are maybe in conflict with what Deborah is saying. At the same time, we need to make sure that Deborah is protected in the expression of her religious speech as well. But likely the email is not a welcome means of doing so. But what's really important here is that everybody's sincerely held religious beliefs should be protected in the office, but we cannot move beyond expressing ourselves religiously to infringing upon someone else's rights. And it's a fine balance, but it's definitely something that I want to point out here. There's also high exposure if Deborah is a manager, as she has authority over the employees. So for example, if employees are interpreting her emails as some command to subscribe to this religion or to follow the tenets of this religion, that could certainly be considered harassment. Ultimately, I just recommend, as far as emails, just to keep the emails work-related and professional, and to kind of keep our personal anything out of our work emails, because again, we just don't know how that's going to be construed. And I would advocate for curtailing, any sort of religious proselytization over email, regardless of, whatever religion it is. I just like to keep it professional. All right, so then of course there's physical harassment. I think this is what we see the most often. So this is unwanted hugging and kissing, massaging, pinching someone, exposing yourself, of course, is a problem. And these are the kinds of things that we typically hear about with sexual harassment, but it's important to note that there are many different categories. Okay, so Linda is a manager, and Nancy reports to Linda, and they begin a dating relationship. It's completely consensual. Neither is married. They're discreet about it at work, and rumors are now circulating among other employees that Linda and Nancy are a couple. So is this a problem? Well, when it comes to dating in the workplace, it would be unrealistic for me to sit here and tell you that there should be no dating in the workplace. Because lots of people meet their significant others. We generally don't feel it's necessary to completely eliminate workplace dating. However, we do recommend allowing managers not to date subordinate employees, even if there are management layers that separate them. So if there is a dating relationship in the workplace, it's typically my recommendation that the reporting lines are severed. So for example, the dating relationship can certainly be allowed to continue. We just don't want those people reporting to one another. All right, let's talk about some visual harassment definitions. So these are our posters, pinups that are offensive in nature. You know, I actually had one client call me, and she said one of her star employees had a Chippendales catalog, or I'm sorry, calendar in her cubicle, and it certainly was very offensive, and it was creating quite the scene. And she wasn't sure if that would be constituting harassment to other people, even though other people were complaining because nobody had actually said anything. It was just a picture hanging in the cubicle. And yes, that absolutely is offensive to a reasonable person. It doesn't belong in the workplace. And that would be a definition of of visual harassment as opposed to physical harassment. Still, again, just as unwelcome in the workplace. Another time, whenever I do this training in person, people always ask me what elevator eyes are. So that's kind of like, you know, taking a long look at someone from like the bottom to their top, you know what I mean, that sort of thing. Also making, you know, obscene gestures at people, unwelcome facial expressions, screensavers in the same vein as, you know, the Chippendale calendar. These are the kinds of visual harassment items that could get us into trouble in the workplace. Okay. Oh, Ken. Ken enjoys looking at pornography websites during his lunch break in his office with the door closed. He's careful not to let anyone else see what he is doing. Is this a problem? Well, I hope all of you think that it absolutely is a problem. But it might be more difficult for us to think, well, gosh, the room is closed and no one else sees what he's doing, so how is this harassing others? Really good question. And it's a trick question on purpose because I want you guys to kind of think outside the box a little bit. Well, let's say Ken ever shares his laptop, for example. So maybe some cookies are saved in the browser, and you know he's closed all the browser windows, and certainly he's careful that nobody else should ever see any of the content that he's looking at. But someone else uses his laptop and inadvertently pulls up from the history one of these offensive sites. Well, now they've been bombarded with, you know, visual imagery that they never wanted to see. Another piece to keep in mind, our IT professionals. They may need to regularly monitor internet activity for anything that could be a threat to the organization from you know, a technological perspective. Now, if they are monitoring the networks and all of a sudden come into contact with this kind of content that they never wanted to see, again, they would have no way to stop that. So yes, obviously I know that we all think that what Ken is doing is probably not a good idea, but I really wanted to think about the other people that may be affected, even if Ken doesn't realize that they are. Okay, and then we discussed bullying in the workplace a little bit earlier. Again, our friends in California have set the stage. They are the pioneers in making this officially unlawful conduct. But just so all of you know, if you're thinking, gosh, I don't really have to worry about this, it's not a law in my state yet, I believe that 2016 and 2017 will be the year that we see a lot more states follow suit after California. So certainly have your antenna up for that. But in the interim, there is nothing stopping you from having a voluntary anti-bullying policy. I certainly recommend that you do, and we can help you develop one of those in the HR Support Center. So again, we don't want to spend too much time talking about what this is. It's just abusive conduct that's threatening, humiliating, or intimidating, again, to the reasonable person. Okay, so what might you do outside of work that could get you into harassment trouble? We're not going to spend a ton of time on this. I could literally talk about this next subject for a whole hour, and I do in other webinars. But think about what's happening on Facebook or on Twitter, for example. We've seen a lot of that in the HR Support Center recently where employees are harassing each other outside of work and on Facebook. And many courts have said, these are small courts, but many courts have said that the employer actually is liable if it knows about this on the Facebook page or on Twitter, for example, to stop it. So my general recommendation, again, this is a very, very tiny Cliff Notes version of what I typically talk about for an hour, is to just not be friends with your employees or subordinates on Facebook. There's way too much risk, and you know, you get information that you didn't necessarily need to know, and once you have that information, you might need to act on it. Talking about social media just a little bit more, don't post or send messages that are harassing. Pretty straightforward, right? But believe me, it happens in the workplace. You want to make sure your employees understand as well that that can't be happening. Harassment prevention does apply to social media. Again, many courts have ruled that if the employer knew about it, they need to do something about it. So again, best practice, just stay away from the social media pages of employees. I recommend don't friend employees. Don't post information on the internet that could be used against the company. And of course, don't review social networking sites for employment purposes. Okay. So let's talk a little bit about liabilities and remedies for harassment. So we're not going to get into details regarding the statute of limitations or damages or anything like that. But let's talk just about what could potentially happen and in what time frame. If you're at the place where you've already been, advised of a severe and pervasive activity that has resulted in a lawsuit, it's definitely encouraged that you get legal advice from your attorney. So at this point, we're just going to discuss how to prevent it from ever getting to that point. Disciplinary action, again, depending on the frequency and the pervasiveness of the allegations, once you've investigated, you could certainly provide a warning. Now, the only time that I would ever recommend a coaching is if it was something that was seriously said without malicious intent. Maybe the person just really didn't know. There have been a couple times when people have used what they thought were just common language identifiers that are actually offensive in nature and in their roots. People just don't know that. And so in that case, if somebody, were to report that certain words like that have been used around them and the employee just didn't know any better, that would be coaching. Anything that regards intent, so anything that was actually said with the intent to hurt someone else, should definitely proceed beyond any sort of coaching. That actually should be disciplinary action. I hope that makes sense. You could certainly suspend while pending the results of an investigation if you feel that the employees who the investigation is surrounding should be separated. That's okay. Ultimately, termination of employment might be something that is required if it turns out that your investigation does uncover severe and pervasive harassment. Okay, so who is liable for harassment? Well, managers and supervisors are personally liable. Your employer, of course, is liable. The actions that a supervisor commits while working for an employer will subject the employer to liability. So as employers, keep in mind if your employees are doing something that's not appropriate, you could be directly held, in fact, you will be directly held liable for that behavior. That's why it's so important to make sure that we're preventing harassment in the workplace. Employees, of course, who are harassing each other, they are liable. And then lastly, I want to talk about non-employees. This creates a lot of confusion for my clients. I had a client who had a UPS driver coming in and making, just offensive comments to the receptionist. And the receptionist complained, and my client wasn't sure if they could do anything about it because that was not their employee, that was a vendor. Yes, you absolutely can do something about it. You can contact that person's boss or their employer, and you can certainly say that that person can't come to the organization anymore. But yeah, you could be held liable if a vendor is harassing your employees. So certainly something to keep in mind. Now, what might you lose? Well, there's a lot of things that you could lose, but I think the most important piece here as a manager, you could lose your reputation. If it turns out that you actually have been harassing employees, or if you knew about harassment and didn't do anything to stop it, nobody's really going to want to work with you. And again, I know that's a bit of an extreme scenario, but for me, I think before damages and penalties and garnished wages and all of the other, monetary items that come into play, I think your reputation is your most valuable asset. That's solid gold. You want to protect your reputation and make sure that it's not damaged by any allegations of harassment. Now, what can the complainant win in a lawsuit? Well, there's lots of things. Lost wages could be restored. Punitive damages might be awarded. Attorney's fees may be required. Court orders and so on. But ultimately, the worst case scenario is being, the new Griggs v. Duke Power, for example. And these are the national cases that have made headlines and have become case law. against harassment in the workplace, that sort of thing. Let's move into the complaint response and the roles that managers play. Okay, so as supervisors, we really are the front line when it comes to enforcing our policies. Employees aren't going to immediately, go to the CEO or the CFO or the HR manager unless they report to the HR manager. They're typically going to start telling their supervisors if they're uncomfortable, and they might not always do so in a direct way. It's very rare that I've ever had an employee come to me and say, Rebecca, I'm being harassed. They'll say things like, my manager singles me out. I feel like I get the lion's share of, busy work, and I know it's because my manager just doesn't like me. And these are the kinds of things that we're going to hear from our employees that really should put our antennas up a bit to make sure that we're looking into the situation to see if there's any actual unlawful harassment occurring. As managers, we absolutely can create a culture that prevents harassment from occurring. And as soon as you know about activity that's happening, even if at first you might think, this probably isn't that big of a deal, what you want to do is document that you received the complaint and look into it to the best of your ability. Now, it might come back that, really nothing really is happening here. Nothing has occurred that would meet the definition of severe and pervasive harassment or even abusive conduct. But your best line of defense is to show that you took it seriously and you immediately investigated. One thing that I always like to talk about is that immediate word, and I'm not kidding when I say immediate. If an employee brings a complaint to you that sounds like it could even possibly be harassment at 4:59 on a Friday, guess what? We want to take immediate steps, anything that we can do to start looking into that right away, and then certainly document the steps that we took. Because if it were ever said, I told Sally that this was happening and she didn't do anything, your investigation notes are going to be the proof that you operated in good faith and due diligence toward that employee. Okay, so Fahad, I'm sorry, we went back one slide. So with complaint reporting, we want to be sure that the supervisor or the chain of command is perfectly acceptable. It is okay for someone to skip steps and go directly to their supervisor's supervisor if they feel comfortable, for example. They need to understand the complaint procedure, and they should also never feel that they shouldn't bring their complaint to a manager or supervisor of their choosing, because the next step after taking it somewhere in the organization is to take it outside of the organization to our friends at the EEOC. We definitely don't want that happening, or their attorney, for example. Okay. So Fahad, you've known him for a number of years, and he tells you that his coworker, Cindy, is making sexual advances towards him, and he finds it uncomfortable. You offer to speak with Cindy, and Fahad responds by insisting this is a private matter and demands that you do nothing to respond. So what should you do? Well, regardless of his feelings about it, again, as a manager or supervisor, you must investigate and stop the harassment. So if an employee requests that no action is taken, we still must respond. And if an employee makes a off-the-record report, which I get all the time, you still need to respond. And even if there is no complaint, so for example, if the employee says, I'm being singled out or I'm being treated differently, just makes an offhand comment like, then you still need to respond. And again, just witnessing the conduct is enough to require employers' response. Now, suppose Fahad, the employee who complained to you, never came to you, but instead went over your head and talked to your boss about the problem. What, if anything, should you say to Fahad about coming to you first in such matters? Well, again, this is really important. He needs to feel that he can bring his complaint to anyone in the organization. So telling him that, oh, next time don't go over my head, that could be considered retaliatory against him for reporting harassment. So it's important that any employee feels comfortable bringing their concern to any employer in the organization. So this is what we typically refer to as an open door policy. Now, retaliation is typically any case that we see a retaliation claim is usually immediately also alleged with that as well. It's been like the hot trend these days to file a claim of harassment and then come up with allegations of retaliation as well. And one of the best ways to combat this is advise the person who's bringing this to your attention, thank you for bringing this to my attention. Please know that there will be no retaliation in response to this. We definitely don't want to question or criticize anyone for bypassing the chain of command, because again, employee attorneys will talk to their employees about that, and they will consider that a claim of retaliation. So no questioning, thanking them for bringing it to management's attention, and leave it at that. All right, so we have a couple of minutes left. I want to make sure that I give you all a chance to ask questions. So I am going to try to get through this just a little bit quickly, but still coherently, of course. And please keep in mind, I will definitely have time for your Q&A. So the employee who complained to you about Cindy, he comes into your office, he's very upset, and he indicates that he's uncomfortable with the investigation of Cindy and he fears retaliation. He tells you he's going to quit. Well, what should you do? In this situation, I know this is very common. What we want to do is tell the management or tell him that the management team has a legal obligation to investigate all complaints of harassment. Tell him that the company is committed to ensuring that retaliation will not occur and that you hope he'll reconsider his resignation, and leave it at that. So recent harassment updates, there are verbal bullying of a non-sexual nature. It may still be considered sexual harassment in some of the cases that we've seen. Uninvolved employees can sue over affairs between supervisors and coworkers because they feel that they were not given the same special treatment. Gender identity is absolutely protected, and gender stereotype harassment is illegal. So definitely keep these in mind. All right, so let's jump from illegal harassment to illegal discrimination. Now, this is treating someone differently with respect to an employment action or decision based on a protected category. So you're the manager of a group of employees, and you find that they often come to work late. And you tell them that in the future, anyone who is more than 5 minutes late will be written up, and anyone who gets 3 write-ups for tardiness will be terminated. Well, Grace and Bill both get 2 write-ups apiece. This morning, Grace and Bill were both more than 10 minutes late, and just as you're about to fire both of them, Grace announces she's pregnant. As the manager, what should you do? Well, the key here is consistency. Consistency and documentation are 2 of the most important factors. Ensuring that disciplinary action is consistent to past practices as well as is documented, even verbal warnings, should be noted and recorded in order to ensure that they're accounted for. So that's the first piece. We want to make sure that we have all of our disciplinary actions written down. Now, I definitely understand the trepidation with an employee who announces a pregnancy, and then of course you're thinking, well, now she's protected, Rebecca, that means I can't do anything. That's not the case. So if the response is not to discipline Grace comparatively to Bill, Bill could file a claim against you for discrimination. And guess what? So could Grace. She could say that she was being treated differently due to her pregnancy. Some people commonly refer to this as reverse discrimination, but it is discrimination, full stop. So consistency and and in conjunction with your policies and practices. All right, so let's talk about some other types of discrimination. So direct evidence. This is discrimination based on a membership of a protected class. So, for example, this isn't a job for a woman. Treating similarly situated employees differently is considered disparate treatment. And then disparate impact. This is a little bit more nuanced, and it's often difficult for employers to understand. So this is a neutral selection procedure. So for example, there's no discriminatory intent, but it has a statistically significant adverse effect on protected categories without business necessity. So for example, if you're requiring a advanced college degree, for just an entry-level, receptionist position. Well, this is going to be inappropriately singling many people out who could potentially do this job. and just requiring something of them that is not actually necessary to perform the essential functions of the job. And this is something to definitely keep in mind. Many courts have ruled in these cases that minorities have been inadvertently singled out by the employer. Again, the employer's intent is never to be discriminatory, but the selection procedure results in a fundamentally discriminatory result, and that's what's really important here. If this is happening in your organization, we want to make sure that we're taking steps to immediately stop that. Okay, so potential risk areas are, for example, of course, hiring and firing. There's potential risk there if we're doing anything of a discriminatory nature, but also disciplining people differently, having adverse promotion selections, distinguishing duties and titles on the basis of protected classes. These are definitely potential risk areas. Almost all anti-discrimination laws will use the phrase terms and conditions of employment. So what this means is that all parts of the employment relationship can be or can appear to be discriminatory. So definitely keep that in mind. And then, of course, in our hiring process, we definitely want to avoid any questions that, even if our intentions are good, could potentially expose us to claims of discrimination. So, for example, asking how old are you when you really just want to know if they're lawfully able to work in, let's say, your restaurant, you're going to be asking them to serve alcohol. Well, in your state, they need to be 21 years or older to serve, right? You can say, are you 21 years or older? But just asking how old are you, that's not an okay question, even if what you're really looking for is can they perform the essential functions of the bartender position. Asking when did you graduate, that could again be considered age discrimination. Asking if somebody was in the military, if they didn't post anything about the military on their resume. And please don't ask anybody if they're an alien. These are kinds of questions that are not acceptable. However, if an employee has military background on their resume, treat it just like any other job. Ask them about the essential functions that they performed and whether or not they feel that they would be related to the position that you're looking for. If you absolutely require a degree, so for example, if you're looking for a scientist, certainly you can ask if they have a degree. You can ask if someone is bilingual or speaks Spanish or French or Portuguese or what have you, if they actually need to speak Spanish, French, or Portuguese to work in that job. But we definitely don't want to just arbitrarily ask people if they speak other languages, because that could be considered national origin harassment. And just a couple more here on the screen. I think you kind of get the idea between what's okay and what's not okay. Let's talk about Ming. I think we have some time to talk about Ming. So you hire Ming for a customer service manager position because she was the most qualified applicant on paper, but you were a bit troubled by her heavy accent. After Ming has been on the job only a few weeks, you've received 3 customer complaints that they were unable to understand Ming and that she seemed unable to understand them. Well, what can we do in this situation? I personally just have so many issues with this case scenario. It's a trick question, so I definitely wanted to save the best for last. It looks like we did not have an up-to-date job description when we were interviewing. And who is the person that hired Ming? It sounds like the job was not properly communicated. And we don't really know what the job description says regarding language skills, communications with customers over the phone, and so on. So it sounds like we really did not set Ming up for success here, and I would really want to look at our hiring procedures before we took any action against Ming. Potentially we could move her to a position that would be better suited to her skill set, but ultimately this just goes to show that bad hiring decisions can happen if we rush the hiring process and don't have an up-to-date job description. Okay, so at this time, I'm very excited to talk with all of you about the questions that you've chatted in. I'll go ahead and turn it over to Sarah. Just one second.
Perfect. Thank you so much for that, Rebecca. That was really, really great. Yeah, we are going to go ahead and review some of the questions you've chatted in. You've got some great ones. So stay tuned. In 30 seconds, we'll be back to answer them. Thanks. So this is a really good question. What are some signs that harassment might be occurring but has not been reported? That is fantastic. Oftentimes, what I'll see is, just an uptick in disciplinary concerns or disciplinary matters. We have a department who employees just are not engaged. You see absenteeism, for example. You can tell that employees who used to be very passionate about customer service, suddenly they're just not engaged. These are some of the things that we can, be on the lookout for. Oftentimes, if you see that sort of thing happening, you can do some informal just observations of the work environment. You could graduate to maybe just a formal survey of the employees, and just kind of note the general tone and demeanor of the coworkers as they interact with each other. Oftentimes, there will be symptoms of a hostile work environment before anybody makes any reports. So really good question. Ooh, here's another good one. What about company events where there is a lot of alcohol served? My goodness. 'Tis the season for company parties, and I certainly don't advocate for, having a party where no alcohol is served whatsoever if your culture of your workplace allows for some moderate alcohol consumption. However, there is a ton of risk associated with that, both from an employee relations perspective and just from a general risk management perspective. So what I would recommend in these situations, we all know that alcohol impairs judgment. It's just a fact. There's no human alive that is immune to the effects of impaired judgment when they're under the influence of alcoholic beverages. So what I recommend is to have a drink ticket maximum. I typically say 2 drinks maximum sponsored by the company. I also would like to have professional bartenders hired to make sure that nobody is overserved. I typically recommend, and you guys can see I'm very risk adverse, and I'm so sorry to rain on everyone's parade. But I also typically recommend that alcohol is stopped being served at least an hour before the event is set to conclude. And lastly, I recommend that you have cab services available for anybody who may be drinking, anyone at all. And again, I mean, you can see, I know that's a lot of steps to take, but it's really important that we, as employers, are mitigating any risk that we're exposing ourselves to inherently by having alcohol at our events. Super good question. Okay, so I think those are the questions that I have. They were mostly along the same lines. So what I'm going to do now is just go ahead and turn it over to Kristen. Kristen, go ahead and take it away.
Oh, I just want to thank you so much, Rebecca, for your time today. What an incredible webinar. We covered a lot of information. A lot of it's stuff probably difficult to speak about. Maybe these are questions that directors of HR may not feel comfortable asking, or they're difficult situations. And so thank you so much for going over that and helping us feel more comfortable in how to move forward in those different harassment situations. So again, everyone, thank you so much for joining us today. Thank you to Sarah and Rebecca, our partners over at HR AnswerLink, for your time. We hope you found this to be informative. And if you missed a moment or there was a slide you wanted to go back and review, don't worry, because we're actually going to be sending you the slide presentation in a follow-up email concluding the webinars. So have a wonderful afternoon, and you'll be hearing from us soon.
Thank you, everyone.